were done with grave errors and gross misrepresentation, which resulted in a miscarriage of justice. In a counter affidavit filed on Thursday, October 12, Tinubu said the apex court should dismiss the forgery evidence tendered by Atiku on the grounds that the deposition of the registrar of the Chicago State University, Caleb Westberg, was conducted by U.S. attorneys rather than certified judicial officers. The president claimed that the content of the deposition could not be trusted, adding that it was not held in a neutral setting because Dutchett LLP, the legal firm representing Atiku, selected their West Walker office as a venue. Now, let me tell you what he said. He said, and I quote, "I know a fact that neither Gwendolyn Bedford nor any other person present at the deposition is a judicial officer. Dutchett LLP referenced as a venue of the deposition is the law office where Angela Liu Esquire, counsel to the first appellant therein, serves as partner." Hello, good evening, and welcome to the Political Spotlight right here on Voice of the People 90.3 FM. My name is Esther Mwachuku. We'll be right back after this break. Welcome back. This is still the Political Spotlight right here on Voice of the People 90.3 FM. The camp of the presidential candidate of the People's Democratic Party in the 2023 election, Atiku Abubakar, has described President Bola Ahmed Tinubu as the forger in chief. Now, the statement was made today via Atiku's media advisor. Now, there has been a back and forth about this particular certificate debacle. The president has responded to the Labour Party's presidential candidate Peter Obi. It is not surprising that he is also still keen on the presidential candidate of the PDP for his appeal of fresh motion to not be, admitted by the Supreme Court. Okay, so Atiku's media advisor Paul Ibe claims that the world has come to the inevitable conclusion that Tinubu is a confirmed forger in chief on account of his serial forgeries and lies in the last 50 years. He stated that Tinubu, a former Lagos state governor, has forged and lied about every aspect of his life, his heritage, his name and date of birth, his education, certificates and work experience. According to the discovery of Tinubu's records at the Chicago State University and the court-ordered deposition in the United States, it's only a tip of the iceberg that has been the litany of his forgeries and lies. He, however, noted that the attempt to drag Atiku Abubakar into Tinubu's drowning arena of forgery must be seen for what it is, an attempt to minimize the allegations of forgeries that he has to contend with. Now, Paul Ibe said, and I quote, "Contrary to Bola A. Tinubu's forgery shopping allegation against Atiku, it is on record that the change of name of the former vice president, reverting to Atiku Abubakar from Sadiq Abubakar, is well documented in an affidavit dated 18th of August 1973, spanning over a period of 50 years. years, which incidentally is as old as the commencement of Tinubu's life of forgeries and lies, which is in the public domain. Paul Ibe went, however, to disclose further that now let's put Bola Tinubu's life of forgeries and lies in proper perspective. In 1999, Paul Ibe narrated that Tinubu lied under oath in his Form CF001, which he submitted to the Independent National Electoral Commission, INEC, that he attended St. Paul's Primary School, Aruloya, Lagos, Government College, Ibadan, Chicago University, and Chicago State University. It has been established, according to Paul Ibe in his write-up and his response to the president, that he attended CSU and that he secured admission into the university by impersonation. Paul Ibe went further to say that through the discoveries of his records in the Chicago State University, we now know that Bola Tinubu forged a secondary school certificate of Government College Lagos, a HSC certificate from Cambridge University, and a transcript from Richard Daley College which belongs to a female owner. He also went ahead to disclose that we also know, thanks to the discoveries, that the CSU few days to graduation in 1979 notified him of outstanding or carrying over, as it is known in Nigeria, pre-qualifying examinations in English, mathematics, and comprehension, which never appeared on his transcript to have been retaken. Also, after his odyssey in falsifying the educational qualifications, Bola Tinubu claimed in his 1999 affidavit to contest for the position of governor of Lagos State that he had a working experience with Arthur Anderson Accountant Deloitte and Mobile Nigeria. It ends up that both claims on Arthur Anderson and Deloitte, both in the USA, are false because his footprints are nowhere to be found in those corporations. Like CSU, Paul Ibe said, Deloitte denied ever knowing or having any Bola Tinubu in their employment, and he has since stopped adding that to his official or public records since his exposure. Yet, he said again, curiously, handlers of this same Bola Tinubu have smuggled Adekunle a middle name that magically popped up in his so-called National Youth Service Corps certificate into his Wikipedia on the 6th of October 2023. This may yet be another indication of a master forger at work. For the purpose of clarification, all the names that Atiku Abubakar bears are traceable to his family tree. Okay, so it may be quite, I don't want to use the word insistent, especially via this platform where we keep talking about the president's certificate. A couple of critics have actually asked questions that there are so many issues to be delved into, to be talked about. This particular CSU certificate of the president has actually been quite a long one, and let's just wait for the Supreme Court to do its, do the needful. But the question is, while we wait for that, is it possible for the president to not mention anything about it? Would we say that possibly the new updates we get about the CSU certificate is a deliberate attempt to keep on talking about it in the news, while possibly other aspects of the president's policy implementation are not looked into or possibly well examined? And then, everyone keeps talking about it. If the president is very keen on people just letting it be while the Supreme Court does what it's supposed to do, then why coming up in the news all the time to give an update on the CSU, or basically the appeal or the fresh motion from the People's Democratic Party or the appeal from the Labour Party? For the past 3-4 days, the president has been reacting to the appeal of the opposition political parties that has been already filed and tendered to the Supreme Court. So everyone is asking, why not wait and let's see how things go with what transpires at the Supreme Court? He has been keen in saying that particularly the fresh motion for a new evidence to be tendered about Caleb Westberg's deposition should not be admitted at all. And then he also talked about the fact that the Supreme Court should dismiss the appeal of the Labour Party because it lacks merit and basically no local standard. Well, we're going to be talking about this extensively. I am supposed to have two guests, two analysts in the studio. The other analyst who is a constant on this program will be joining us later. We hope he joins us later because he traveled and just returned today. However, I have a legal practitioner, a political analyst, and a social affairs commentator, Barrister Evans Ufili. Barrister Evans, good evening and welcome to the Political Spotlight.
Good evening, Esther. Good evening, viewers.
Yes, I'm sure it's been quite a, will I say, good week for you? Good but busy week?
Well, it's okay. I traveled, I just returned.
Yeah.
And, that's just it. I'm back.
Okay. So let's look at the entire imbroglio, because we've been having this conversation on and on. We had it last week. Because of last week, it was a different story entirely. This week again, we keep hearing new information concerning this particular CSU certificate. On Friday, the president asked particularly that the deposition of Caleb Westberg, particularly in Atiku's appeal, because apparently Atiku filed a fresh motion for the Supreme Court to admit this new evidence. You know, we've talked about it. Yes, exactly. So he's telling the Supreme Court to not even admit that fresh evidence, because according to the president, he's saying that whatever the Presidential Petition Election Tribunal had already confirmed should be what the Supreme Court should stand on. He also said that there is really no need to actually drag this, because according to him, the elections went well. Nigerians voted, they made their choice. The elections were free and fair. There was no malhandling of anything, no corrupt or misdealings occurred during the elections. And so whatever appeal that the Labour Party and the PDP are filing to the Supreme Court against his win should be entirely discarded. For Atiku Abubakar, though, this is the third time he's actually, saying something, meet the deposition. Particularly, he mentioned that of Caleb Westberg. Do we think the legal team of the president is doing him more good when they keep talking about this? If everything is left in the hands of the Supreme Court, why don't they wait till when everything commences? Or could this be a deliberate distraction?
I think it is the expressions in their counter affidavit,
okay,
that is being discussed, because there is an affidavit filed by Atiku seeking the leave of the court to admit the new evidence procured in the United States, which was actually one of the fundamental issues for determination in the court, in the tribunal,
okay,
which has now gone to the Supreme Court. As at the time that case was at the tribunal, the evidence was not available, and now that it's available, the normal thing to do by law is that you bring a motion, you come by a motion on notice,
okay,
stating that if you look at section 22 of the Supreme Court Act, it says that the Supreme Court is empowered to even hear a case as though the case is coming before it for the first time, and anything that gives you the power to hear a case or to have a case being relitigated has also conferred the power on you to admit evidence to that regard.
Okay.
Because by section 22 of the Supreme Court Act, Supreme Court can even take witnesses.
Okay.
To clarify parts or the whole in an issue, can listen to the case as though the case is coming before it for the first time, and like trial. So, but it is natural that the adverse party must file a counter affidavit. A counter affidavit is the response to a motion on notice. Okay. In that counter affidavit, the president legal team, expressing the president's thought, are saying that the new evidence should not be admitted. Should not be admitted because, one, it is procured during the pendency of the case. And if you look at the Evidence Act, clearly, it is wrong for you to procure an evidence during the pendency of a case.
Okay.
That's what the same Evidence Act also says, that whoever wants the court to act on a piece of evidence must prove the existence of same. You understand? So
must prove the existence of same.
Yes. So Atiku wants the court to act on the evidence he got.
Okay.
So he has proven the existence. by procuring that evidence.
I think it's going to be quite a tough one. I don't know how the Supreme Court will go about this because, well, before I continue, if you're watching us live via YouTube, I would implore you to actually, comment on the conversation we're having. This opposition political party, the APC, that he used a false name, that his name was inconsistent in some of his past forgery evidence. This time around, he went full on. He said, throughout the forgery evidence tendered by Atiku Abubakar, especially on the grounds that the deposition of Caleb Westberg, the registrar of the Chicago State University, he said it was conducted by U.S. attorneys rather than certified judicial officers. That's what he's saying now. That's the reason he's given for that particular deposition of Caleb Westberg to not be admitted. If at all, the Supreme Court would admit the fresh evidence, that they shouldn't pay attention or take heed on that particular evidence. Now, you do know that on October 12, he filed a counter affidavit to defend himself from Abubakar's petition, seeking an annulment of his election victory at the top court. Now, in it, he implied the content of the deposition could not be trusted. And I want to read out what he said. I know as a fact that neither Gwendolyn Bedford nor any other person present at the deposition is a judicial officer. He asserted that the Nigerian leader, in a calculated move to discredit Mr. Westberg's testimony given in front of all the respondents' attorneys on October 3, that he tainted the deposition by implying that it was not held in a neutral setting because Dechet LLP, the legal firm representing Mr. Abubakar, selected their West Waka office as the venue. He referenced as the venue of the deposition, that is the law office where Angela Liu Esquire, counsel to the first appellant therein, serves as partner. So he's saying that, based on all he is saying, he said he doesn't trust the deposition. He said because he did not have a ground to choose where the sitting could be held or the deposition could be held, and that the persons who were there are not judicial officers. So based on that, that is not a strong standing and should not be admitted. I need you to explain what that means.
Well, a deposition is supposed to be before a commissioner for court. That is also how it is in the US.
Okay.
Okay. But when in your counter affidavit you are saying that the Supreme Court should not admit the deposition because the location it was the deposition was made was not the right one under the law.
All right.
A counter affidavit can contain anything, can contain as much. You have to discredit the motion on notice.
All right.
Okay. Because the counter affidavit, you are saying that you disapprove of what you are countering what is contained in the motion on notice and the affidavit in support of same. Okay. So you are going to have dissent. Okay, when you say counter is you take each paragraph one after the other. Okay, because that's you take them one after the other and you quash them accordingly.
All right.
So the Supreme Court will now look at it and now determine whether or not that deposition was rightly made or not. Okay, like we said in this case, this matter is sub judice. So whatever we say here is as a matter of education.
All right.
And most times we are enlightening the people on the processes of law.
True.
We are not going to usurp the authority of the Supreme Court to make pronouncements as to what the outcome should be. That is why the question should be tailored around what could possibly be the implication of a motion on notice to admit a fresh evidence and a counter affidavit asking the court not to admit it. Okay. And all that. The court will now decide. But if you look at Section 22 of the Supreme Court Act, as I said, it empowers the Supreme Court to, the Supreme Court to even rehear a matter that already been heard by a court below. Okay. And like anything that will make you to rehear a matter or to relitigate a matter has also conferred on you the right to admit evidence to that effect. But it's still on the discretion of the Supreme Court to so do. Okay, at this stage now, this stage, you cannot bend any decision henceforth from here.
You cannot bend any decision.
You cannot.
Who can bend any decision?
No, you can bend decision on the Court of Appeal ruling. What they call it, the
Presidential Election Petition Tribunal.
the petition has made their ruling, right?
Yes.
Parties are at the appeal now. One party is saying no, go this way. Supreme Court, go this way.
Yes.
Don't go the other way. But at this stage now, whatever pronouncement the Supreme Court is going to say or make cannot be bent. There's no other route to further appeal.
Okay,
that's what I mean. And because we're at the final stage of this, it is also largely on the discretion of the Supreme Court to admit the evidence or not to admit it. Remember, there's a portion of the Evidence Act that says that you cannot procure an evidence during the pendency of a case. Like when a case is ongoing, you are now, the court presume that if you are going to do a case, you should have all your evidence. But not that when the case is already ongoing, you're now going to be scouting for evidence at the same time. Okay, and then when you now scout for evidence, you now bring you by motion with a leave of court and say, please take this motion, take this evidence and use same. Okay. The same evidence as says that whoever wants the court to act on a piece of evidence must, state the existence of same.
All right.
Must produce it. You understand? So when you put all that together, you find out that everything boils down to the discretion of the Supreme Court on this, whether or not they are going to admit. You see, the thing is that if you admit a piece of evidence, it does not mean that party has won.
Oh, really?
No.
Okay.
Sometimes evidence are admitted, but the weight the court will place on it will be very low and minute. You understand? So, but Nigerians feel that
like what's transpired at the tribunal.
Yes, Nigerians think that once an evidence admitted, therefore the other party have lost. No. The reason for admission may be based on strict principles of law, but the content of the evidence, does it have the capacity and the weight to turn the decision already made to the other side? That's another issue entirely.
Okay. All right. Also, remember I told you earlier that I was going to have another analyst right here in the studio that would help us broaden the conversation this evening. Well, and that's Barrister John Wokedi. Barrister John Wokedi, welcome to the Political Spotlight.
Thank you so much.
Thank you for taking your time. I know you traveled and you just returned, for taking your time to come on the program. It tells you how committed he is. So thank you once again.
Thank you. It's my pleasure.
Barrister John Wokedi, I'm sure you're already enlightened with most of these issues that we're talking about this evening. Once again, we're still on the president and his CSU certificate. For the past 4 days, the president has been pressing and insisting to the Supreme Court that the appeal filed by the Labour Party and the People's Democratic Party should not be adhered to. For the PDP, he is maintaining that the deposition of Caleb Westberg particularly should not be admitted. In fact, I just read it out before we came in. So another thing he's actually trying to say is that he seems ready to exploit the West Waka location as a legal loophole. That is the location where the deposition was held. He's actually questioning. He's saying that the admission or the deposition of Caleb Westberg cannot be taken as truth, as there were no judicial officers there, according to him. He says that this particular legal showdown for Nigeria is actually drawing very close, and he has come clear, unsheathed his sword. He's leveling serious allegations of identity fraud and forgery against, his main opponent in the February elections. He has also challenged Mr. Abubakar to explain why he bore Atiku Kojoli in his primary school certificate and Sadiq Abubakar on his 1965 West African Senior School certificate. He has gone all out too. He also said for the Labour Party presidential candidate that his deposition, or rather his own appeal, has no moral standing. Basically, to him, he just told the Supreme Court to discountenance it, standing on the grounds that the elections that were conducted on February 25 were authentic, and INEC declaring him as a president was basically logical. So the Supreme Court should not admit or listen to any fresh evidence or fresh appeal tendered by the opposition political party. And I'm worried. I'm a little bit worried because it's, as an executive, the president of the nation, is it possible that whatever it is he keeps insisting on could actually hold sway with the Supreme Court?
It is not.
Okay.
By what law ought to be, it is not. Nobody is above the law, whether the president, the commander-in-chief of armed forces, the whatever parastatal, like governor, chief of army staff, and every other person. No one is above the law. Everybody is guided by the provisions of the law,
Okay.
the provisions of the constitution, the ground norm. We call it the ground norm, the supreme law of the land that has in its own section that any other law that is inconsistent with its provisions shall, to the extent of its inconsistency, be rendered null and void and of no effect, including that of the president. It has binding effect on all persons and all authorities throughout the Federation of Nigeria, all persons. So, but because people enforcing these laws are humans, and humans actually have their shortcomings and shortfalls. So in the process of trying to give human face to the provisions of the Constitution, they will compromise, either compromise, bringing emotion, bringing sentiments, bringing comradeship, bringing fraternity, and the rest of them. That is why it appears as if some categories of people are above the law, or the president is above the law because of enormous influence he wields, both politically, financially, and otherwise.
All right.
Yes. But in the face of it, which we know as prima facie in law, the president is not above the law. But the question now is that can the court summon enough courage? Because we had the interaction where I traveled yesterday. It's a gathering of lawyers anyway. You are also asking me as an analyst my view. Just almost the same question asked me now was asked to me a very informal sector yesterday. I told them in a civilized society and climb that the law is above the president, takes effect above on everybody. But in Nigeria here, based on what we have been witnessing, not just now, right from 1979 when we have a fully embraced presidential system of government, it has become almost impossible for the courts to remove a president. But if our judges, the Supreme Court judges, and I also told them in civilized society, just like what we saw in America that played out recently in CSU issue, that the judge, McDonald of a person, was on the side of the public view. It was on the side of public interest. She even said that the registry has received so many mails from people of Nigeria asking that they want to know what actually happened in that certificate. So her own, emotional disposition towards justice, she aligned with that what people actually wanted to do. But unfortunately in Nigeria, our courts are tilting towards backing the government.
You think so?
Yes. That is where we have issues in Nigeria. I'm a lawyer, I know what I'm saying. If they take me on, I'll prove it. Most of the matters taken to court that will enhance the powers, the influence, the authority of the people, court usually throw them away. They mostly give judgments that will consolidate the powers of the person in authority. So that is why the country is not even growing democratically, because now court is to enhance the growth of democracy by being people-oriented, giving more powers to the people, making people to triumph over certain issues against the people in authority. I mean the public. That is how democracy develops and developed in other climes. But in Nigeria here, the court is more or less tilting towards the influence of those in authority, consolidating their power in authority, consolidating their grip of power and everything. And that's why you see them becoming very, very, having this impunity, becoming very, very bold and daring and telling nothing will happen, that will do something and nothing will happen. Because they know that even if they have done something very, very odious, very, very offensive against the public and go to court, that one way or the other, court will tilt towards their own direction. And the court, in such a way, in doing it, courts always believe that let government be, let government move, let let just the system be stabilized. Let's just take off. That was actually, because if you remember today, people still remember Awolowo versus Shagari's judgment, and it dealt a very terrible blow on our democracy then. What was their reason? Let government be established. Let somebody be in power. Let us move. Do you understand my point?
Yes.
Now? Where are you moving to? You are moving into doldrum, into unfathomable political hellhole, into economic quagmire, and we are still moving. So this present case now, if you see many people now, let everything just end, let it die, let the person there continue, let just have a government, let just have a system.
All right,
at the end of the day.
Okay.
So then, from the issue of admissibility of what you said in matter before the court, I've said it. They have the right to bring the matter before the court. I actually read the Atiku's appeal or the grounds of error you raised there, and he said this Supreme Court rules of 1985 that enabled them to bring that fresh evidence before the court. So they have the right. They came by way of order. They have order 1, order 2, order 3, or 4, 5 rules, so and so. So it wasn't. They didn't come just by inherent jurisdiction of the court, but you can say come by
specific.
Yes, because if you don't have any order to rely on in a matter, you can still bring your application based on inherent jurisdiction of the court. But if you have a specific order that authorizes you to bring such application before the court, you come by word of that order. So Atiku's lawyers came by word of an order. Could mean there's an existing order that allows a person to bring in fresh evidence. The issue of Tinubu saying the deposition, but the only place I have issue there now is that they have conflicting affidavits.
Okay.
And when you have conflicting affidavits,
who has conflicting affidavits?
Yes, Atiku came by word of affidavit.
Okay.
And Tinubu is countering it now by word of affidavit. And it's already before a court of final jurisdiction, highest jurisdiction. Now, when there is a conflicting affidavit, you call oral evidence. But at this point in time now, they cannot do that.
Who cannot do that?
Both parties cannot call fresh evidence at Supreme Court. They cannot call fresh evidence. You cannot call witnesses to testify, because if I depose affidavit that I was never at this VOP today, blah 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 blah. You depose affidavit that I was here, blah blah blah. What court should do is to call
a witness
call us to
testify
before the doc, and then cross-examine us on the validity, authenticity, or otherwise of the content of that affidavit. Not extract who is saying this truth or who is not doing that.
And meanwhile, we've gone off that stage where they can do that.
So that is where I'm saying that Supreme Court may have issues on which one to.
They
may decide not to even admit.
They will say find their way.
That's section 22.
Yes.
Powers the Supreme Court to rehear.
Yes.
To act as a court of assistance. In exceptional cases.
Exceptional cases. Yes. Okay. In that case,
so whatever gives you that, whatever empowers you to hear, has also empowered you
to call witnesses, call witnesses,
examine and admit the same power that section 22, the power that gives the Supreme Court the right to admit documentary evidence, also confer the right to hear oral evidence.
It's just that they have not done it before, or maybe this might be the first time that they will exercise that authority and then implement the rules. So Atiku actually. He has the right to
waiting for you to land because I really need to.
He has the right to do what he has done. So whatever affidavit they have deposed to that place, I wonder why Tinubu is telling them that citing what actually transpired in that place.
Right.
It's an affidavit. It's the content that the court looks at and the probative value of that affidavit. Probative value. Sometimes court may not even look at how you obtained evidence or whatever. It's probative value of that evidence. Yes, whether. Like I said it, I think that I don't know what it was here. I said it. If I use gun and broke into this place and gather everything we have here and then beat everybody up and tender it in court, you can't say because it was wrongly obtained. I didn't seek maybe you are sleeping when I got it, or you are bathroom and I came and picked it. It's same material before the court. What court looks at that thing I got, has it any weight to the issue before the court? That Arabo Shela versus Ayola. That was where court firmly established that principle. So Tinubu relying on that is just like, but being, like you said, the president, we know what transpired at the tribunal. No. All the things that were flying around the social media eventually found their way into the judgment.
All right, Barrister Evans Ophelia, I don't know if you recall last week, the former NBA president, that is Nigerian Bar Association President Olusegun Agbakoba, said he was disappointed in legal practitioners who have been making comments on this entire CSU saga. In fact, he's saying that since the case is still in court, or while there's still a court proceeding, that no legal practitioner should be talking about it. And that elicited quite a reaction from several quarters. Some persons believed that Olusegun Agbakoba definitely was, in a subtle way, speaking on behalf of this administration, on behalf of the president, because his tone sounded like somebody who already picked a side. Well, he recently conducted an interview, and in that interview he was asked to say something about the ensuing certificate controversy, because there is no how, or there is no way you click on any of the news outlet, you're not seeing an update concerning the CSU certificate saga. So it is expected that most media organizations, most media houses would seek the legal perspective of some of these legal practitioners, and possibly what all of this entails and what may portend in terms of giving a prediction, even if they cannot rule. And he said something. He said he cannot comment, he cannot make any disclosure, and he said for the Supreme Court is going to be very tough. He said, unfortunately, I can't make any comment on the Chicago State University certificate issue. I don't talk to the media when a matter is pending in court. If the matter is decided, then I can comment on it. And he said that it is important that the unsettled issue of the Supreme Court be decided so that we can put it behind us. He further noted that anyone that emerges as president will then face the challenges President Tinubu is facing presently. So according to him, he said there are quite a lot of issues that the president needs to look into, rather than him being his attention being diverted, or him being distracted about the certificate saga. In other words, he actually portrayed that the legal team of the former vice president, as well as the presidential candidate of the Labour Party, should put a lot of things aside and possibly not even try to comment or make any reference whatsoever until the Supreme Court hears the case, and then we know the final ruling. What do you think concerning the perspective Olisa is coming from?
Well, Olusegun Agbakoba, with due respect to him, is very wrong in what he has said. But very wrong. Very wrong in the sense that when a matter is before the Supreme Court, it is not the law that you cannot talk about it. What you must not do is to begin to tell the court what to do.
Okay.
Or predict the outcome.
Or begin to predict the outcome. Or begin to talk about who should be what, when, and how. The media houses are not lawyers. The media houses conduct their programs on topical issues. The most vibrant topical issue we've had in the past 1 month is on this certificate saga.
Mm-hmm.
Okay, so are you saying the media houses should not invite lawyers to talk about it in terms of the principles of law? Or are you rather saying that no lawyers should talk about it, they should get non-lawyers to do the analysis? What will become of the public in terms of public enlightenment? Okay, we are not just lawyers because we have to go to court or earn money or defend our clients. We are lawyers beyond order. We are lawyers to shed light on legal issues which are quite incomprehensible by the public. Okay, our duty is not restricted to the elites. Okay, This society must be redeemed. This society must understand. I mean, when the court of first instance gave judgment in this case, we saw how the whole country went agog, and non-lawyers trying to make interpretation of laws, and there were a lot of errors flying here and there. Imagine we had no lawyers at all doing analysis. What would the atmosphere look like? So we'll be having the blind leading the blind. Okay. So what lawyers are doing is critical. What he should have said was that lawyers should not predict the outcome. Lawyers should not usurp the authority of the Supreme Court. Lawyers should not act like though they are so knowledgeable in the law that they will predict what will become of the case before the Supreme Court make a final pronouncement. There's no part of the law that says that lawyers cannot make comment on a case. It should not turn itself to the Supreme Court or make a semblance of same in the analysis of that matter. If, for example, we talk about certificate, a journalist asks me, when do we say a person has committed forgery?
All right.
It does not necessarily mean the president. In the light of this case, when can it be said that a person has committed forgery? in the light of law? I will answer. A person is said to have committed surgery when this and when he does this or that. Does not necessarily mean I'm discussing the case. So when it comes to public enlightenment, lawyers owe a duty to the public, and that's part of our training.
Exactly.
So I see that as very wrong. If he says he's not going to comment, well, fine for him, but he should not disturb those who are making comments on the issue.
Professor John Wukete, last week, I think between Wednesday or Thursday, thereabouts, the presidential candidate of the Labour Party organized a press conference. In that press conference, literally, he addressed the president. He told the president to let Nigerians know who he really is. He said, people need to know who you are. We need to understand the person that we call our president, because you represent us internationally. You make decisions for a lot of us. We may not be there, but you literally make decisions. The decisions you make will mar or, will either mar us or make us. So we need to know whom you really are. And a couple of persons would say they're not surprised with the response of President Bola Tinubu. Now I want to read out what his response is to Peter Obi's appeal. Tinubu said Peter Obi's appeal, which was based on allegations, was dismissed at the Election Petition Tribunal. He argued that the presidential election was peacefully conducted all over the country and that the results of elections were carefully and accurately recorded in the various forms of EC8As. Now he went further to say that the entire petition was nothing but a jamboree of sorts, which was prosecuted more in the media than in the courtroom and the lower court. Being a court of law and not of sentiment, dutifully threw away their petition off after a painstaking consideration of saying, if considered from every angle, it is lacking in merit, substance, and good faith. And that unlike previous election petitions over which this honorable court has presided in time past and made far-reaching pronouncements on diverse issues, including but not limited to ballot box snatching, vote buying, voters intimidation, interference by the military, thuggery, ballot stuffing, violence, disenfranchisement, non-recording of votes in Form EC8A, which is a building block or the base of the pyramid, and such other electoral vices, this appeal arising from a dismissed petition, the main grounds of which is that while the presidential election was peacefully conducted all over the country and results of elections carefully and accurately recorded in the various Form EC8As, some unidentified and unspecified results, even in the appellant's brief, were not uploaded electronically to the IRA portal. So he said that Obi failed to prove his allegations of non-compliance and corrupt practices as required by law. Instructively, however, the lower court, appreciating that it is not a court of final instance, proceeded to determine the petition on its merit. Now, what basically Tinubu is saying is that when the petition was tendered at the court of first instance, that is the tribunal that was just concluded, he said that basically all Peter Obi did, or whatever it is he tendered, were more for media attention. The nitty-gritty of the situation he did not present. Secondly, most of the issues that were usually witnessed during elections, which could be a strong pointer to even his case or strengthen his case, which is violence, thuggery, apartheid, and a couple of other issues, voter disenfranchisement. These are the main core issues through which the court could actually make a proper listenership to. But that even there, he couldn't even bring any evidence to portray whatever it is he said that was experienced during the elections. So for him, elections were properly and transparently concluded, and that the particular appeal of the Labour Party has no merit, so the Supreme Court should discard it. But based on his response and based also on the press conference that was conducted by the Labour Party presidential candidate, can you put them at par?
Has he answered the issues raised in that press conference organized by Labour Party, where the presidential candidate responded?
His response has been he intends to focus on issues that will make the economy move forward and strengthen economic policies.
No. I read somewhere today where somebody said that you cannot feed the hungry by a stolen loaf of bread. But basically, there will be issues. You are raising more criminals than solving the problem of hunger. Because when people discover they are giving them bread that you stole from somewhere, you are raising more criminals in that community than solving the problem of hunger. That's exactly what Tinubu is trying to do in Nigeria. if we don't address all the raging crisis affecting the personality of the person, Bola Tinubu, and then move our minds into economic or whatever they call it, we stand tantamount to going somewhere to go and see a loaf of bread and use to feed a hungry person. It will raise more fraudsters, more forgers, more crooks, more people with questionable character, and all sorts of things in the country. And I have not seen any country that have actually made progress when such a country is populated with such character, where you cannot trust. There was something that happened where I went yesterday. I lost my wallet. I didn't know where it was. I started panicking. Why I was panicking was not because this is Nigeria, that maybe someone has actually taken it and that person will not return it. Luckily for me, it dropped somewhere, and before the person will pick, somebody that knew me saw it. So how do you see that environment now? A place where you are not even secured, wherever you are, where you believe that even well-dressed person next where you are having a drink is a criminal. So how do you now think that foreign investors, foreign business people that do not even know the terrain at all will feel very comfortable to come to such environment and transact business and build the economy and begin to grow the economy? How do you grow economy? You grow economy by having a very functional legal system, a very well articulated attitudinal problem of the people that populated that site, and then a functional system and institutions. These are the things that will enable any foreign investor to have interest in any site he wants to invest his money. And then how do you grow economy when you don't have them? So the press conference that PW actually organized raised the main issue that Tinubu ought to quickly take advantage of. Come out and tell Nigerians who he is. Even I read what Dele Momodu actually said in somewhere. He said, why not, if you have done this, apologize. Come up and say something. Let people hear you. Because you are building a monstrous kind of youths. The problem I have with all this, like somebody was telling me yesterday, he said, Joe, on our own side, by God's grace, we have escaped to a certain extent, a large extent. But what are people coming behind us? Would they escape? Would they have the opportunity at that time?
Okay.
Answer is no. So we cannot build the economy when the personality of the person at the helm of affairs is lacking in merit. It's questionable. Look at what he's saying about Atiku. Atiku forged this, Atiku forged that. Why didn't you take Atiku to court? Atiku took steps by taking you to court, initiating proper legal proceedings to unravel everything about you. Now you are the president, you have all the apparatus of the agencies at your disposal, EFCC, ICPC, police, DSS, at your disposal. Launch attack into Atiku's credentials. Take him to court. Also, prove him that he has forged. They will know how many forgers we have. You don't just go and begin to cry foul. Because people are viewing it now from angle of mischief. That was because you have exposed you. That's why you are not going. Even though in law, we don't look at something like that. As far as offense is committed, it's immaterial whether it was done out of mischief or hatred or whatever. Once it is established that the offense has been committed, it has been committed.
Okay.
So the issues P2B addressed in the press conference, Tinubu should come out clear to tell Nigerians who is a man that his age is in doubt, primary school certificates in tendered 1970 when the school was established 1974. His primary school, I was like, does it mean he didn't go to school at all? And he speaks well, and I can't say without any atom of hate, he's a human being like me. I wouldn't say that someone like Tinubu did not go to school. He doesn't behave like somebody that did not go to school. But his grammar, his exposure, his everything. I have to say Tinubu just grew up in the street and became whatever he is. Why can't you tell us where something that went wrong? He definitely speaks well. Just some my points now. He cannot be a governor, coordinate people who do those without going to school at least a certain level. But then tell us the one he went to.
That's a question. That's a question.
Or who actually went to that school?
Because even with Deloitte, when he was asked questions, did you work at Deloitte? Because he was asked, where did you start making? The company has said nobody of that name they don't have that in their file.
Then how did you grow up? Are you a ghost? Can we say what we read in mythology, that you are born and brought up in another world, finish everything, that came back to Nigeria, became a new human being? So I was asking them, we don't know your father, we don't know your mother, we don't know your elder brother, your elder sister. They've not come up and said, this is your elder brother. We only started knowing your family, that you married, kids you gave birth to. Every other thing is like blood. school you attended, we don't know your classmates. I was in anywhere, it was my classmates I went to meet there. We hung out together. Primary school, I know them. So how did you come about? Everything was like, under speculations, under, intensive interrogations, under a kind of questioning. So let him come out and tell us who he is. But we still hope, no matter how dim it might be, that maybe God may touch the Supreme Court of Nigeria to do a magic. Even if it's like, yes, to do a magic.
Do a magic.
Do a magic. Because I where I was yesterday, one of them, it's a brother to send to Suez, the CSU, the one that just died. That was soon, I think on the 19th of this month, we buried. The younger brother was with us yesterday. So he was telling us what one of, I saw the tribute from CJN. He said, we are already dead, even though we are living. That was what he said. We are dead, even though we are living. Yes, that was tribute Ariwala wrote. I have access to all those things. And so many things that transpired in his own life too, which I will not say in the public here. But now he's gone. He is gone. So these people should also know that the time shall come when we eventually go. So let them save the generation, present generation, the ones unborn. Let us create a society where equity and fairness, where people will stand on truth, and that truth will eventually prevail. I said, let Nigerian judges. I know what I'm saying. I'm going to court tomorrow. Last week I was on court Monday, Tuesday, Wednesday, Thursday, and high courts, not just magistrate courts. I was in court. Let our judgments be pro people.
Okay. Let
the judgment, it cannot grow democracy. I mean, this is not military era where judges are like under strong kind of fear and trepidation for the military people. This is democracy. Let them know that democracy is a system of government that will nurture and grow into becoming that real people-oriented government.
All right.
Let them be pro. Like in Kenya, even when they wanted to dodge the bullet, they nullified the election and all that very wrong. And as people now saw that they were able to achieve something, even though the same Uhuru contested and won. And the Supreme Court acted, at least they did something that made the Kenyans know that this particular election, court said that we're going to nullify it. They nullified, they said, let another election be conducted. Nigeria should just do something that will make people know that people are supposed to be the winners, not those in authority. Because, like I said, they embolden these people so much that you see them bragging. Like there was a judgment that even that CSU was delivered, this Lawan versus whatever. Yes. And somebody bragged that whatever, that Lawan. And this was, that CSU was where we were yesterday discussing his life and time. It was a big minus. It's no longer with us. But all of us were in agreement that he did wrongly there. So now it has gone to the grave with him.
The man did not contest election and he won.
Just about, it has gone to the grave with him. Even at his exit, he's still in the mortuary now. We're already now making pronouncements that look at the area he did something fatally wrong, and he's no more. So this system may go with you.
Now, Barrister Evans, amongst other things, Tinubu is contending that because the 180 days allotted for the hearing of the election petition have passed, the Supreme Court cannot now exercise trial jurisdiction in the matter. So, in other words, he's actually stating, basically based on what he's trying to counter, like the counter affidavit you mentioned, he said that, for example, at the Presidential Election Petition Tribunal, that's the court, that the opponents did not challenge the outcome of the most recent presidential election on the grounds of forgery before the Presidential Election Petition Court, and that they continued by saying that making the new evidence peculiar to the proceedings, not only because it was presented by the trial court. Now, a statement by Okpeyemi Bamidele, if you recall, that he was the only witness that, spoke on behalf of the APC, and he's also the majority leader in the Senate, pointed out that Atiku and the PDP never submitted any evidence, documents or depositions from the CSU in support of their fourth basis, which relates to Tinubu's purported ineligibility before the Presidential Election Petition Court. Now, Bamidele is saying that if they did, Tinubu would have had the chance to answer appropriately and bring up the inconsistencies with Atiku's credentials. So he said these are contained in the counter affidavit and written address filed by Tinubu through his team of lawyers led by Chief Wale Olanipekun in response to the application by Atiku and his party seeking the permission of the Supreme Court to introduce fresh evidence in their appeal.
Well, like I said before, counter affidavits, you have to go the whole hog to look for laws. See that issue raised now. Now the 180 days has elapsed.
Yes.
I know the same Supreme Court that ruled before that the 180 days cannot be elongated, cannot be moved. In fact, it went further to say it's like the Rock of Gibraltar that cannot be moved. Now, it is smart for a lawyer on appeal to remind the Supreme Court that 180 days has elapsed. And you have a judgment too that says it cannot be moved. It cannot be.
So, in other words, because of that.
And it's a constitutional provision.
Wow.
You understand?
Wow.
Which supersedes every other subsidiary law in Nigeria. Now, but you see Section 22 of the Supreme Court Act, how be it a subsidiary legislation empowers the Supreme Court to, for the purpose of clarity, to hear, to even act like a court of first instance. Now, the Supreme Court is slightly, most times, even though we are not supposed to predict the Supreme Court, we're only going to say that it's a general knowledge that the Supreme Court, the Constitution overrides every other law in the land. It's a smart argument because if you look at it, after 180 days, it is closed. In fact, the Supreme Court too can be foreclosed after 60 days. You understand what I'm saying? The Supreme Court too can be foreclosed after 60 days because that is the window they have within which to determine the case under reference. Okay, so
and that 60 days, when did it start counting?
It started counting from the day they filed and served.
So where the Supreme Court is supposed to sit anytime from now, or?
Of course. To hear the matter. To
hear the matter, because it's been more than 2 or 3 weeks that they filed.
What you normally do is, even though this one, there's a motion, this one, on regular Supreme Court matters, they will sit on what was transmitted as a record of proceedings.
Okay.
From the court below. But in this case, the evidence they intend to bring in was not part of the evidence transmitted.
Okay.
Because it was not an evidence in the lower court. You understand? So that's why they came by a motion on notice, seeking the leave of court. And then you cannot have a motion on notice without a counter affidavit because the other side will respond. And then the other side is saying that 180 days is an issue.
Okay.
2, don't admit evidence because it's fresh. And they have given a lot of authorities and to that effect. So, like we said, when it gets to this point, there's a whole lot of discretionary power that the Supreme Court exercises. At this level, the Supreme Court make laws.
Yes, they do.
The judiciary make laws. That's what they call decided cases. We call them laws, judicial authorities. You understand? The Supreme Court have the power to bypass its own act. It may not bypass the Constitution.
It may not bypass the Constitution.
It will not bypass the Constitution.
But it interprets the context of the Constitution.
It will interpret the Constitution
to suit certain circumstances.
Based on the letters and intention of the legislature.
Yes.
You understand? But it can bypass a subsidiary legislation. So, what is the Supreme Court? That is why we have won over and over again. Nigerians don't talk about an electoral reform system that will give us an electoral system that the citizens can decide who will win and who will lead them. They don't talk about how to make a reform. They allow the politicians to mess up the system at the field. Then all of them will now gather and say the judiciary is our problem. Now it is the Supreme Court that want to determine the mandate of about 8 million persons who voted.
Meanwhile, the mandate is meant to be determined by the people.
By the people.
And not the Supreme Court.
Yes, not the Supreme Court. So whatever the Supreme Court whatever the Supreme Court does, the Supreme Court should not be held accountable because originally speaking, not the responsibility of the Supreme Court
to decide.
to so decide for the citizens who
But
lead them.
but
Because of the crisis you have in the political system,
you must
there's no other institution that is
you
responsible to resolve disputes.
yes.
Well, those are meant to
crises are bound to happen.
Yes.
Now,
Or
what
two or three or four persons must not agree.
Yes.
Now, is it unconstitutional, right? If possibly a group, a team, or a cabinet, or whatever is formed, whereby they will be the main deciding factors, they are the representatives of the people to decide how elections should go.
It's not the same thing with the court.
It's something now.
But apparently, it's always like the court has always disappointed when it comes to the aspect of whom
That
the
same
people
factor
actually
that
want.
made the court to disappoint will still play out in those people.
The court is blind to who the people want.
The court is blind to who the people want.
Yes.
If the court is blind, then why should the case rest in the court?
I need to complete the statement. I just gave you the first part. The court is blind to who the people want. The court is restricted to the evidence that have been presented before the court to determine. That is why if you look at the court of first instance, when the matter was ongoing, supporters of a particular political party had their own issues for determination in the social media. Different from the issues of determination presented by the lawyers of the party they are supporting. And they wanted the outcome to be based on the issue of determination they have for themselves, as against what was before the court.
Interesting.
So what will happen is that the court will not go outside what is before it. Even if the court finds you rigging, it's not the court that will come out and say too it was rigging. No. You who have alleged that he rigged will present the evidence upon which the court will ground your claim. So that's why I said the court is blind to whoever. So if somebody rigs and you came to complain that there's substantial non-compliance, and then you came with haphazard evidence that cannot grant the claim, no evidence at all. Don't expect the Supreme Court to rely on what it saw on its own. It's going to rely on what you have before the court. So that is exactly what will happen.
All right. Now, why I was trying to take you, why I was trying to ask you that question that I didn't want my train of thought to get lost, was that if the court is actually blind to what the people want.
No, I'm not saying the court is blind to what the people want.
Okay.
That's not what I said.
All right. Explain.
The court is only active to the evidence
presented before it. So,
as against what people are clamoring for,
or as against what may have actually have transpired.
If what they are clamoring for is not well couched before the courts as processes filed in the courts, if they are not well captured or concerned, and if those things are arguable issues, or those things are issues that my court might find probable or substantive enough to compel decision to be made in favor of party canvassing it. Do you understand the point now? Because some things might be flying around social media, but before the law court, they might be immaterial.
All right.
They might not be the substance of what
might even be different from what
may rely on. And there might be something that might be like done out of ignorance. And there was something that rose up somewhere where somebody was, I don't want to say it, but that person, when I listened to that argument, I quickly told them, look, this might sound immoral, but it is legal. It might sound very, very immoral.
But it is legal.
All of you shouting here now, you are shouting because in your mind it is immoral. But being immoral does not make it illegal. I think something might be very, very immoral, but then in law, it is legal. And it will be treated as illegal. So in your own mind, you might be thinking that, okay, court has done something very, very terrible by not, making that thing that seemed immoral to become illegal.
Okay.
I said there are two different issues.
So are we?
We're not trying to 100% exonerate our courts.
All right.
Yes.
All right.
We're not trying
what I want to ask is, what about the court of the people?
Yeah, they are culpable.
What I'm saying is, do we have a court of the people?
There's no court of the people. It's the same court you see today. That is there. You see the court of the people. That's the same court established for the people. Number one, it depends on the lawyers handling the matter. That's why in most cases, if you want to like prepare cases, you bring in the litigants. An office will call them twice. At the time of preparing our exhibits, they're always before we exhibit. By the time we want to file, we'll call them again. We'll ask questions. So I will be able to like convert those grievances into what will constitute what will file in court.
And most times you have them to write the story themselves.
Yeah, they'll start stories and they'll be there. They'll be there when you read it. They listen to you. Tell them, is there any other thing? Sometimes when they have a kind of things that they may strengthen their case, you may look at them. They may not have any moral, any legal ground.
Okay.
So in that case, you discard it. Say, this thing you said, in your mind, it is like very, very strong point. But in law, it will amount to nothing.
Okay.
But then in Nigerian courts, because we're not going to exonerate the courts 100%, they are also part of the site. Like what Mark Donado did, she did not only determine that case based on what was before her.
All right.
She also determined that case based on what was before her, and based on the interest of people of Nigeria.
Yes.
She said it in her judgment.
Yes.
Based on the interest of people of Nigeria. Our courts are too technical. They hide under the cloak of technology to perpetrate so
That
many
is why I asked.
injustices.
That is why I asked the
And you must
question.
say it.
That's why I asked the question.
You must say it.
Barrister
And the
Joe.
way they let me finish you.
Wait, that's why I asked the question. I said, do we have a people's court?
Where they want to do something that is like against certain people, they'll go beyond that their desk. They go. I know matters they will say court is not for Christmas. It's not true. In most cases, they are for Christmas. In most cases, they go beyond to make sure that they deliver judgment they want to deliver. Some instances they'll ask for rely on judgment. I don't want to say so many things because that is where I go to. Because I want us to be very, very honest and very sincere. If we want to get a strike that all of us will be proud of, we're not going to exonerate. Courts, judges were once lawyers. Some of them did not go to court to any altar call to repent. So we have to know all these things. Some of them they did not go for altar call for repentance before becoming judges.
Okay.
They only went for trainings. So some of them that are terrible, even as students. Some of my classmates are not
Many of them did not practice as long as we practiced before they became judges.
Some of them were like handpicked from their relatives, connections,
They
and
didn't go through the rigorous exercise.
Practice as long as we practice.
And some of them are representing some interests. The discussion we had yesterday, which I told you was like completely with lawyers, we raised all these issues. It was like we are repeating what we said there. I can't say certain things here because it's not the same environment. I know strong political groups that actually fronted judges, and they are serving now. Strong political, I know them. We even, since they mentioned them, we mentioned like almost 10 that they appointed judges from strong political connections. So what do you expect them to do when they get to the bench? To begin to go against those that even influence the appointments? They will not do that. So that's why when I listen to what Chido Professor Odinkanu said, it's going to the roots. Part of how to like purge the judges of all these bad eggs is to review the procedure for appointing judges.
Okay.
Like I will say it, Mary Odelina, the two daughters are at federal high courts. Are they there because they're smarter than other lawyers that want to be there? No. Ariwara, I think he has his son. His son is also in high courts there. And whatever. Federal high court. What is he doing there? Like my learned friend here said, has he practiced for how many years? How many contentious cases has he done? Has he built that class and charisma as a lawyer before being appointed?
How stretched?
How stretched? See, there was a man I was appearing before one day. He said, Joe, I was like you. I was on the other side. Joe, I know what I want to say, Joe, because I was like you before. I was there for 18 years before I came over here. Joe, look at what the problem this thing will cost me.
We need to start taking calls.
He said, this is the problem this thing will cost me if I do it, because he has been grounded in practice.
All right, Barrister Evans, you made reference to something. You said you know a particular political party whereby what was possibly clamored either on social media was not what they tendered in their petition.
Yes. The issues they had for determination, what they were asking the court to do in their prayers, were actually different from what their supporters on the street, who never read the process of the party they are supporting, were different from what the people on the street had. the people on the street thought that the court of first instance we, on the basis of their own thoughts, that because some people were being chased in Lagos.
Some people were being chased in Lagos.
In Lagos, some people were not allowed to vote.
Even in rivers.
We're being disenfranchised.
In some parts
of Lagos.
Yes, that once that one is said in court, then the court will cancel the election.
Okay.
A lot of people had that mentality.
Yes.
So, not knowing the rigorous nature of the proceedings in court.
Proving sir.
Yes. So when the Supreme Court petition, the court of what they call the presidential petition gave the judgment, they came out so disappointed, so heavily disappointed that I know of one who could not eat because he was disappointed. And I asked question, what were you expecting? He said the way the election went now, that we know that
I think yes.
all over the country,
Yes.
it was that this way, that way. Therefore, why should they? So now, when you try to educate such kind of person, you see, this is a course we study under 5 years, and by the time you are concluding the 5 years, you do another 1 year trying to integrate into the system proper before you start populate. I mean, populate, you don't. Populate, sometimes you are not even paid. You are just there going through the process for another 5-6 years.
Yes.
Before you even begin to understand what is going on in court.
But it's what it's all about.
You see these law students that come out from the school and say they are going to excursion on the court of law. When they get to the court, they just sit down. They are just like
Sleeping
any other person
yes,
in the gallery.
Some will be sleeping.
They don't
I'm not
understand.
paying attention
They
to
don't-
proceedings.
Who's understanding what is going
If you pay
on?
attention, you will not know what
They will not know what is going on.
You don't know what is going on because what they are teaching you in school is substantive law.
Yes.
Substantive law have no basis on procedural law.
Yes.
Substantive law is just to help you begin to think like a lawyer.
Yes.
That's what they are trying
That
to achieve in that
mindset.
5 years is to ground your thought, take your mind, turn it upside down, supplant it with law. You understand? So that at the end of the day, you want. But when I went for my first interview, the moment I got there, the man looked at me and he said, "Yes, have you been called over?" I said, "Yes." How many years? I said, "This is my first listen." He said, "Don't even worry about. Have you been called?" I said, "Yes." "Okay, don't worry." He shook me and said, "I will breathe the law into you." Because coming out from the law school, you don't know the law. You don't know it. Let alone someone who is a civilian, who is on the street.
That was against what Bokabasan said.
Who is completely.
They get enlightened by all these programs.
You see, because if you want to go strictly by the rules of law, you see this press conference that Atiku granted
Yes.
and the press conference of P2B,
Yeah.
they are all wrong.
They are wrong.
They are wrong. You are the litigant in court. This case is before a court. Those press conferences are not needed because you have submitted jurisdiction to the court. You have so it is court that will determine. Even if there should be a press conference, it should not be you standing and talking.
Should be the party.
Should be the party.
Let's see.
You understand? So, but in our society, we just downplay these things. See, that's quite it's subjudice. It's wrong. You understand? So, even the politicians are not also well guided. Their followers are not also well guided. And this thing has to do with a lot of experience and the knowledge of law. If you go on social media, you try to educate as many people as possible. What they do is to turn down your thought and begin to abuse you. Resist knowledge, resist everything. They have a mindset, and that mindset is that it's what they want that will play out. But you not only play out
the problem we have is that what people call wrong must be wrong. That's just
Barrister Joe, because I need to call out the phone line so we can take calls. President Bola Tinubu and his vice have argued that the case by the Allied People's Movement challenging Shetima's nomination to contest the last presidential election was a mere waste of time of the court. Now, we do know that the APM in its petition before the Presidential Election Petition Court claimed that Shetima violated the provisions of the Electoral Act on the grounds that he allegedly had double nominations as candidate of the All Progressives Congress. Well, it prayed the court to, among others, void the joint presidential ticket of Tinubu and Shetima, thereby claiming that the vice president allegedly irregular nomination has affected the competence of the joint ticket. Now, in furtherance to that, the Tinubu is appealing at the the same time, I told you he has talked about that of Peter Obi, that of Atiku Abubakar. So he's saying that that of the APM shouldn't be tendered because they literally wasted the court's time, that the Supreme Court already gave a verdict, a judgment on this particular case, and that there was no need for them to actually proceed to the Supreme Court. They said the position failed all through to the Supreme Court, where this court made very instructive pronouncements on the subject matter of the complaint. So Tinubu and Shetima are listed as the third and fourth respondents in the appeal, and they argued that as against the appellant's claim, the vice president was validly nominated as he lawfully withdrew from his earlier nomination as a senatorial candidate. So we've been saying the back and forth, although the president has not organized any press conference, like you said, all this while, he seems very confident in his standing, just like he did while the case was at the Presidential Election Petition Tribunal. What's your take on that? So we can open the phone line.
That's what they will say. But they shouldn't say that a litigant is wasting the time of the court. Even though in most cases, courts will also come by word of that kind of usage, which I always condemn in its entirety.
Okay.
Whosoever that has gone to court to seek redress should be commended, even if at the end of the day the person didn't succeed in getting judgment in his or her favor. Okay. The person used his money, used his time, hired lawyers, and want to have a pronouncement from the court regarding that issue, and decided not to take laws into his hands or recruit other illegal means to seek redress. So I don't like people saying that somebody went to court to waste the time of the... Why is court established in the first instance? If everybody that will go to court will already know that whether you will lose or whether you will win, that means the essence of court is like, a kind of, destroyed. Because people going to court have the belief that they will win. Both parties, court is as the arbiter, will now decide whether this person is right or wrong. So you shouldn't discredit somebody by going to court. And they have a ground. If they don't have a ground of error or appealable ground, they will not appeal. It is their right to appeal. And they have appealed. And the APC and his counsel or whatever they are not the court, they're not the Supreme Court. They will know whether somebody is wasting their time or not. Although lawyers also, one will file, will also say that. I cannot say it is the first time we are seeing that kind of usage. We also use it.
But do you think the Supreme Court will, on the grounds, based on what Tinubu said, that because the deposition was conducted by U.S. lawyers, so the Supreme Court should discard the particular CSU deposition of Caleb Westberg?
I said it before that the nature of how an exhibit or evidence is obtained doesn't matter much to courts. There's this case of Aremboshola versus Oyelola. That was a locus classicus. Was a matter we argued one.
What is locus classicus?
Locus classicus like the measures, the standards, the foundational case.
Okay.
Establish a principle.
A strong principle on
an issue. Okay.
Do you understand my point? So the nature that evidence is used to be obtained matters little to the court. They don't matter much. What court looks at is prerogative value of that exhibit.
Yes, the fact that the court admits it does not mean you have won.
And for the fact court admitted that exhibit does not mean you have won. Sometimes such exhibit might collapse under the fire of cross-examination. Do you understand my point? Or court might review it and discover that it lacks merit or not attach much weight.
It might be argued
away under cross-examination.
But based on what is going on between two of them, because I need to open the phone, there's something critical. I'm asking you based on what people are asking. So these two affidavits, this counter affidavit, the affidavit of the Atiku Abubakar and that of President Bola Ahmed Tinubu, do you see the Supreme Court having to accede to the request of Atiku Abubakar's legal team?
The only thing I believe that Supreme Court may look at is time factor, time frame.
Okay.
Such an exhibit. If they want an escape from that, but if outside that, anything they want to rely on, I'm just telling you, I does not get my support, because that exhibit came from authority for United States.
All right.
And it's on a particular issue, and it was an exhibit deposed by someone on a particular issue before the court. So for me, it is relevant.
For you, it is relevant, but the Supreme Court may not consider it.
And it has prerogative value because it touches on issue before the court.
Yeah.
It's not like something else. It has prerogative value. From my own assessment, and not the court, because it's not like something different from what is before the court. It touches on the main issue of what is
fact in issue.
Fact in issue of what is before the court. So courts cannot just discard it or throw it away.
The source of admissibility is relevant.
It's relevant. The court will admit it, and then look at other things. They say, but Tinubu's lawyer relying on the fact that because of the place it was procured, this and that, in law, court doesn't really attach importance to that. They attach importance to what is the worth of that exhibition. What is it? What is the content? That content, whether it has value to the court based on the matter before the court. If I let I'm a criminal, I'm a thief, and you're able to get something like somewhere, maybe something like somewhere under secret or inside the road, whatever, and brought it, and somebody is trying to use to prove that I'm a thief, court do not want to know how they brought it, whether it was illegally procured or not, procured through killing somebody, through killing my mother, or raping somebody, or committing evil. As far as they look at that, that's probative value on that issue of proving me as a criminal.
But the Evidence Act says that if the court have a cause to believe a piece of evidence,
yes,
it will do so.
It will do so.
If it has, you see, it does not even matter where you are bringing it from. If the court is convinced
that this is relevant, admissible, and probative value,
they will believe it and act on it.
And act on it.
If you look at the case of Uzodinma versus INEC and in Imo State, you find out that the evidence that was tendered by police, a duplicate copy of an INEC result, the court had a cause to believe it. Much so that the adverse party did not contend it or object it. The court believed it and acted on it.
Yeah, that's the point.
And people are saying the person who came out first.
So it is
that result was counted into what he had already based on his prayers. That if you have counted,
I have gotten this. So,
all right, you can actually be part of the conversation this evening. The number to call is 0700 903 903 903. That is the number to call. You can actually send us a WhatsApp message on 0700 903 9039. We're also currently streaming live on YouTube, and it's at VOP 90.3 FM. So it's easy when you subscribe. So anything at all, any information that comes out, you definitely get notified that we're already streaming live. All right, so the number is 0700 903 903 903. The WhatsApp number is 0700 903 9039. Hello, good evening, and welcome to the Political Spotlight. Yeah, what's your name and location, please? Hello? Your name is what? I did not hear your name. I'm sorry. Hello.
My name is Carlo. I'm calling from school.
All right, Carlo, please go ahead. Go ahead. I can hear you. Continue. Go ahead.
Yes, my name is Carlo. I'm calling from school.
All right, welcome, Carlo, to the Political Spotlight.
So, I have heard what you have said about the certificate of our president.
Hello?
In foreign countries.
Okay.
Hello?
Go ahead. You have
in a foreign country.
Seconds.
In a foreign countries, it's a country like US or this country. Immediately the state Chicago release that result from the president must step down because he has been the image of his citizen.
Okay.
What am I trying to say is that let the house impeach that president, or let the Supreme Court nullify him, or let the military take over.
No, the military cannot take over. We are still in a democratic dispensation. And then he made a statement. He said that in the United States, that's countries outside here. This is Nigeria. So their laws are basically different from how our laws are here. And the conduct, their judicial conduct, is different from how our judicial conduct here is. 0700 903 903 903. That is the number to call, and the WhatsApp number is 0700 903 9039. 0700 903 903 903, and the WhatsApp number is 0700 903 9039. Hello. Hello.
Hello. Good evening.
Welcome to the Political Spotlight. Name and location, please.
Yes, my name is Mr. Oscar. I'm calling you from Badagry.
Mr. Oscar, please go ahead.
Okay, nice to hear your voice. Good evening to the guests in your studio.
Good evening.
Yeah. Yes, the two Lele colleagues, they have really discussed the matter so extensively.
Okay.
But my worry is the burden of proof.
Okay.
When you look at the burden of proof critically, you discover that he's so cumbersome and stringent in nature.
the burden of proof have to be with the three principles of Evidence Act, Electoral Act, and the provision of the Constitution. We decided cases, the previous cases that have been decided before. Please, I really want to confirm something.
Okay.
For instance, where the cases correlate with the facts and the figure, so obvious and glaring before the public, and the public opinion overrides a decision or a judgment of a court.
Okay.
Well, I'm trying to, because those two colleagues, they are in practice.
Okay.
As they have said, that some of the people who truly pass through law, they
All
are
right.
not into
Continue with your
practice.
question, yes.
Hello?
Continue with the question. You haven't concluded with your questioning. They will respond, definitely.
So what I'm saying is, for instance, where some evidence is so obvious and it's overwhelming, and the public saw the facts and the figure, can the public opinion truly override the judgment of a court?
All right.
Yes.
Thank you. All right. Please kindly respond.
The public opinion would have overridden the judgment of the court if we have an electoral system that is viable and properly reformed. In electoral matter, it is the public opinion that stands ordinarily. The mandate given to the candidate is public opinion. That's why they say Nigeria decides, or during election they say the people have spoken. Okay, it is their opinion, decision as to regards who they want to lead them. That is what they laid down in terms of voting. Okay, but in this case where the electoral system is so fractured that there is contention, there is substantial non-compliance with the Electoral Act, there is disenfranchisement, there is thuggery, brigandage. Sometimes you have so much issues of violence
And voter apathy.
So the litigants then resort to the judicial system because that is the system that they cannot take the laws into their hands. They won't call and take arms against the sea of trouble.
You remember I asked you, I said,
they go to court.
I asked, I said, what about the People's Court? I remember I asked you that question.
That's what I'm saying. Now, once the litigant submits to the jurisdiction of the court by filing case in the court and asking the court to determine the case, it is no longer the public opinion that we override.
It is now the judgment.
Of the court. Okay. Now, the judgment of the court can overlap with public opinion.
Okay.
But when you say public opinion, we're looking at the aggregates
Okay.
of dissenting views and conforming views. Okay, so what you mean by public opinion will mean that if truly Nigerians largely of the particular number 8 million.
The greater almost 70-30.
Yes, 8 million. Even if you look the entire.
Is there a way to conduct that poll whereby you get to feel, okay, if the people are not happy with how the judges or the judicial process makes decisions, let's hear from the people. Is there a way to conduct a poll to do something whereby decision can be based on what the people want?
You can conduct that poll, but that poll is already conducted as far as I think I'm concerned.
Based on the elections.
25% of 25% came out to vote. You can imagine we're talking about a president that claimed victory with 8 million out of 200 million. It tells you that
60 million.
It tells you that there's no legitimacy there. There's no legitimacy. How be it is the people's indolence.
The 14 million people do not want.
Okay.
That came out to vote.
So now, if you look at it, you now have 6 and 8. Okay, outside the scope that brought him in. So if it were to be two-party system, this president wouldn't have claimed victory, most likely, because the votes that were supposed to go to one person was divided by 2 persons.
2 persons.
So, and if you look at the margin of lead from the first and second, it was
the margin was presumed lead, but that's where the problem is.
I know. Well, based on the figures,
on the figures made available
you see, there's no time I discuss electoral matter without talking about electoral reform. Yes. That's where my mind is. Because you see this court thing, we'll never get it right with the court.
Yes, but you know where we have
let's get it clear. We'll never get it right with the court.
And that means it will continue to be like this, because I don't think the president intends to
go back to the polls and reform, clean up the polls.
Especially INEC. The reform has to be INEC. How do we reform INEC?
And you know the whole thing.
Look at what
the
INEC
bulk of
did
what
during the
election
to even get certified to copies
was
of
the problem.
documents.
Documents.
And now
They were
blaming
complicit.
and they're blaming it on the political parties that went to court. Whereas they met proper and legal.
So most times
for these documents to be made available.
But don't you
When
find
we
it
blame
outstanding
them-
that the tribunal court did not even make any blame or reprimand on INEC?
That's why I'm telling you that
When we blame
our
the
courts,
courts.
we are not going to extricate the court. It's already the court in its entirety.
But each time we blame
Court
the
is
court,
also-
Okay.
let's remember that INEC played
Yes,
a very
it's
fundamental
role.
role to the quagmire that we have now. Because
Yes.
everybody says
What's
the
the
judiciary
sense?
is the problem.
No, what's the sense of the court?
Meanwhile, there's a remote.
Let me tell you, I always tell people, I say, do you know why people come to us when they have problems as lawyers? Not that they cannot solve it. They want to look at someone that is well trained and fully equipped, to solve that problem. That's why they come to you. They know that they will not have all the requisite materials and implements and the tools, to solve that problem. That's why they come to you. So as a lawyer, they're not supposed to make any mistake. They're not supposed to make any error in this office. It's not permitted. People pay you to write letters for them. They went to school, they can write letters, but they want a lawyer to write it. That's the sense of a court.
All right, let's take this
Society
call.
knows that.
Hello. Hold on, please. Hello. Welcome to the political spotlight. What's your name, please, and location? Your name is? Are you on the road? Are you in motion?
I'm on the
Well, please call back when you're somewhere more quiet, because where you are is distorting the call. I can hear you properly. 0700 903 903 903. That's the number to call. 0700 903 903 903. Hello.
Hello. Good evening, Madam Esther.
Evening. Welcome to the political spotlight. Please, what's your name?
It's Nemeka from Ejibo.
Nemeka, please go ahead.
Yeah. I'm listening to our two guests.
Okay.
Good job. Well done job, my brothers.
Thank you.
Please, lawyers, I want to use this story about you people. But I'm sorry to use you people as a story. And now I come to remember what Grandma used to tell us about lawyers. Well, I have one that two of his brothers took him to school, trained him very well. But he went and learned law, finish, and he's using this law against his family. Especially these two brothers that send him to school. Whenever I want to cheat these two brothers, they start speaking English and quoting laws.
Okay.
Today, excuse me, I'm talking about our judiciary.
Okay.
Today, this is supposed to be a classroom for a common man. Now, the judiciary of Nigeria has become the workplace a common man wants to attend.
Yes.
Because justice has been built for self. And when a country is living in this way, that country is sinking down. Because the poor people has no hope now in the judiciary. And it's very, very bad to us. It's not giving us a good image. You guys being lawyers.
Okay.
You guys being lawyers.
Thank
please,
you. We need to take more calls, please. When you call a minute, we're almost rounding off, so we can take as many calls as possible.
That's what I'm saying. Court must lambast INEC.
Okay.
Court must say something about the
All
conduct
right.
of INEC.
Okay. Hello.
INEC cannot just go.
Hello. Name and location, please.
Good evening, Evans and my daughter brother. Good evening.
Okay. All right. Please go ahead.
In that deposition, the place the judge said something about public opinion. I know
Okay.
it will not happen in this part of the world.
Yes.
The judge says something there due to the constant request by the public from Nigeria. She's moved to decide according to what Nigerians want. I don't think that will never happen here.
That was Judge Nancy Maldonado.
Opinion we're talking about. Yes. They said the public, because of the phone calls, her line was barraged by phone calls and everything. But here, they know too what they want. They want to work, that's the way they will work. You see, the dissenting view on Hope Uzodinma's case The judge that said that this was going to haunt us, and today is haunting us. Other judges never listen to the man. Thank you very much.
Thank you. I like this. Very straight to the point and concise. 0700 903 903 903. That's the number to call. 0700 903 903 903. And the WhatsApp number is 0700 903 9039. Hello, turn down the audio of the radio completely. Yes, name and location, please. All right, we've lost that connection. 0700 903 903 903. That's the number to call. Let me read out some messages. Olisa Bakoba should go and sit down. He has no right, local standing, or any tiny strand of authority to tell any being not to discuss about CSU certification issues. If he doesn't want to talk about it, he should keep his muteness to himself and embrace his personal decision of silence. As for Peter Obi's press release, it was very irrelevant and needless. Of what use would his statement be? How would that make Tinubu explain or resign? Peter Obi, sometimes I don't know how he transacts himself with issues sometimes. At the end, leaving himself open for oppositions to attack and make mockery of him. As for Tinubu, his accusations of Atiku certificate is like a drowning man, not willing to sink into the sea of guilt alone. He rather holds on to the shoelace of Atiku so that they sink together. If Tinubu is so sure about attending CSU, he should sue the school and Atiku with whatever charges that fit. But to me, he didn't attend CSU. CSU needs to be investigated. All right, you did not put your name. Next time, kindly put your name to any of the messages that you send. Good evening. Anyone who has recently applied for visa would notice that visa officers are taking second looks at application documents now, from birth certificate, spelling of name, to discrepancy in date of birth and date of birth certificate where it was obtained from. Our president's issues is rubbing off on all of us directly or indirectly. Dr. Chris from Undo. Thank you, Dr. Chris, for your message. Good evening, Esther, and your guest. My take this evening is, if anyone goes through in certificate forgery, let them know that they will interpret it very well so that it will be Nigeria's constitution, and let them go and cancel the section which said anyone that presented invalid certificate should be disqualified. My name is Kelechi from Ushudi. All right, thank you, Kelechi, but I did not understand what you sent. Kindly resend properly so I can, understand what you intend to say. Okay, good evening, VOP, and happy Sunday to all the listeners. The simple fact is out there that the president submitted a forged document to INEC since the CSU denied of issuing the certificate submitted to INEC. The evidences are so clear to sane people, but only in Nigeria white becomes black on technicality. I just don't understand why Nigeria is being ruled and led by the worst of the citizens. Imagine every of our laws and the interpretation of our constitution is upside down, unlike the Western democracy we are emulating. Please, we need strong institutions, not strong and criminal individuals who will not allow the country to breathe. Let the president resign and save the country from international embarrassment. Ike Eziobi from Ejibo, Lagos. Wow, that's a huge call you're asking for there, Ike. Okay, good afternoon, sir. God Almighty will bless you, because all what you are saying is truth. Our president lacks morals and the integrity. By now is supposed to step down and apologize to the nation. Austin from Ayobo City. Good evening, Esther. If the Supreme Court didn't do the needful concerning this certificate issue, that means the court and the lawyer are supporting the masses to it. If the Supreme Court didn't do the needful concerning the certificate issue, that means the court and the lawyer are supporting the masses. I still don't understand this particular message. Austin from Ayobo City, please kindly resend properly so I understand the perspective you're coming from. 0700 903 903 903. That's the number to call. 0700 903 903 903, and the WhatsApp number is 0700 903 9039. Okay. Hello.
Hello.
Yeah, welcome to the Political Spotlight.
Yeah, thank you very much.
You're welcome. Go ahead. What's your name?
This is Ajana Davis. I'm calling from Ikotu.
All right, Ajana, kindly go ahead. You have a minute.
Thanks for the erudite lawyers that you have there.
Thank you.
Though I can see that one is leaning towards, let's say, anti-government.
Okay.
So, but what I want to point out is that, please, as much as possible, you don't misinform the public.
Okay.
Someone was talking about the vote cast for the president. So it's got 8 million against 200 million people. If you want to place the vote cast for someone, it's against the registered voters, not against the total population of the country.
All right.
if this is a country where even school starters, they will come on air and they will be proven to know more than the justices.
Okay.
So please, thank you. Continue with your efforts.
All right. Thank you, Mr. General.
We have been educated.
Thank you. Thank you so much. Barrister Evans.
Yeah.
If I understand the phrase when you were explaining at the time, you were talking about how low the voting turnout was. If we look at
25%,
25% compared to 200 million Nigerians.
The issue of 200 million, he has raised that issue. Yeah, it's based on the registered voters. Well, many people are not up to 18. Some persons are also up to 18, but they are not registered.
Okay.
Some are registered but do not get their PVC.
Okay.
Some are registered, their PVC is nowhere to be found.
So in other words, you cannot use that to make comparison as to 200 million Nigerians plus with 8 million that gave the president the win.
Yes, you cannot use that. But even at that, the total number 25% that came out to vote is still a far cry from what we have as total population and total population of registered voters. What I'm trying to say, I was trying to address the issue of voter apathy. That is, a lot of people are disenchanted because over the years we've had this issue and all that. But a time comes when the Nigerian state should understand that the more people that we have in the run of play will determine actually the issue of legitimate. If we had, let's say, 80%, 80%, there's a tendency that the current president will not have clicked victory, or would have,
all right,
or whatever it is. And many of the party supporters, those who support parties vigorously, didn't even have PVC and all that.
All right, thank you.
All
right, thank you. Hello.
Hello.
Yeah, welcome to the Political Spotlight. What's your name, please?
Yeah, my name is Chris. I'm calling you from Magodo. Good day.
Your name is what?
Chris. I'm calling you from Magodo.
Okay, Chris. Kindly go ahead.
Yeah. I want to say kudos to your lordship right there in the studio.
Okay. Thank you.
I must say I commend their submission.
Okay.
I think what you're saying is actually the truth. But you see, Nigeria is a country whereby a lot of people are compromising facts, compromising evidences, compromising things that are very clear that you don't even need a glass to look. And that is why many of us are really crying and we're saying, okay, fine, let's have a judicial system that actually speaks the voice of the people. About what he said that the people can actually override the judicial system. I think yes, but now looking at the way things is being done in this country, most times, you ask yourself on the question is, the way judicial system actually work in this country, it actually gives room for self-justice. Because I don't see reasons why people would do things that are uncalled for and still maintain.
Oh, we lost that connection. We'll take one more call. We'll take one more call because we're running out of time already. So you can take your final takes. All right, 0700 903 903 903. That's the number to call. 0700 903 903 903. And the WhatsApp number is 0700 903 9039. Hello.
Hello, good evening, Madam Esther.
Yeah, evening. Name and location, please.
My name is Romeo, calling from Port Harcourt.
Wow. Thank you so much. Wow, you must be watching us on YouTube. All right, go ahead.
Yeah. You see, the issue here is this. When a poor man goes to court, he is judged according to evidences brought before him. But when it is done to the rich, they are called.
Hello?
If we are saying...
Okay.
Hello, can you hear me?
Yeah, the network is fluctuating a little, but continue.
Sorry. If we are saying about the votes and everything, why not consider, is it today that the judiciary is having a problem? It's not today. But because it is affecting a big man today, it's being looked into. When it was affecting the masses, was anything done about it? That is the problem in Nigeria. When something is happening to the masses, let it be said, let it be taken care of. not when it happens to the rich. Thank you.
All right, thank you. Thank you for that submission. Barrister Evans Ufeli, please, what's your final take on the program?
Yeah, my final take is that the Nigerians should look up to the Supreme Court to do justice.
All right.
Justice could mean the case will go any way. In this court, the Supreme Court had, in this same country, the Supreme Court had made pronouncements. Someone who did not contest presidential election governorship election became a governor. Rotimi Amechi of Rivers State, who was substituted at the primaries level and all that. So the heavens were not for the Supreme Court to do its best. And I implore Nigerians to read the judgment when they are delivered.
Okay.
Read the judgment before you start commentary. It's very important. Most times people conclude on their own even before the court makes pronouncements. And it's important that we get this done. And the Supreme Court should at least make a strong case for the public.
Okay.
Most important.
All right, quickly, Barrister.
I want to make my final analysis. Our courts, not just the Supreme Court, should be more people-oriented. If actually they want our democracy to grow and then become that democracy that will represent the voice, the wishes, the aspirations of the people, and not just being so strict on legal interpretation, especially technicalities. They should deliver justice. I know what I'm saying. Instead of judgments. We have more judgments in Nigeria than justice. And it's not helping our economy, it's not helping our democracy, it's not helping our growth, it's not helping our image. Because if court ratifies certain things that people out there knew quite well was the other way, it doesn't stop them from viewing it the way it is. Look at what transpired at Presidential Election Tribunal that actually gave judgment. So people outside Nigeria, other countries, they still believe that there was something wrong that was done in the election. Did that change their mind? No. It didn't change their mind. So people outside there, other international community, they're beginning to disregard even pronouncement made by a court. Doesn't change their view on Nigerians or what Nigeria is known for.
All right,
so
thank you so much.
Align with what will make people know that we condemn what is evil and we don't want to live with them.
All right, thank you so much. That brings us to a wrap right here on the Political Spotlight. You'll be listening to the Political Spotlight on Voice of the People 90.3 FM. My name is Esther Nwachukwu. My learned girls who are practicing lawyers or legal practitioners, Barrister Evans Ufeli and Barrister Joe Nwokedi. This program will be repeated on the 16th of October, which is on a Monday. So basically in the afternoon, we'll be hearing a repeat of this program. My social media handle is at Esther Nwachukwu on Twitter, Esther Nwaz on Instagram, Esther Nwachukwu on Facebook. Barrister Evans Ufeli.
Yes, I'm Evans Ufeli across all
social media platforms. Barrister Joe.
Joe Nwokedi across all bots.
All right, so that's it right here. Do have yourself an amazing Sunday.
Thank you.
What can you do? Nothing. Oh no! Yes. Hey, you are coming with a bodyguard. Maybe they've told her that I will always beat you. Everybody care.
Thank you for staying with us. The presidential candidate of the People's Democratic Party has remained vocal in his position on President Tinubu's forging his Chicago State University certificate.